please.
Thank you, and good afternoon. It's about 20 minutes to 3 in Kenya, so it's still our afternoon, and I understand it's your evening. Now, the topic that I have slides I hope we can share. Yeah.
Yes, ma'am.
Just before I start, yes. Yeah. Yeah, I think that's the first slide, and it has the topic, role of mediator towards a successful mediation. I'll just, on this first slide, I would just like you to note the seating arrangement is very important in mediation. The lady in the middle, that's the mediator. Those are the two parties. Yeah, okay. We can move the slides. Now, on this slide, I have 3 topics. What is mediation? Who is a mediator? What is the main role of a mediator? I think it's very important to understand what is mediation, because it's quite often confused with other forms, other mechanisms. It's quite often confused, especially with arbitration. And when I when I say what mediation is, I think we will be able to distinguish. Mediation is a voluntary, informal, and confidential process which takes place with the consent of all the parties involved. In mediation, a trained neutral person, and I've used the word trained neutral person, it doesn't have to be a lawyer, it can be anybody with any background, law, medicine, engineering, whatever background. A trained neutral person, a mediator, assists the parties to work towards a resolution of a dispute, with the parties themselves remaining in control of the final decision. That is my definition of what is mediation. Now then, this begs the question, so who is a mediator then? If that is what mediation is, then who is a mediator? A mediator is an impartial, neutral, independent person, trained, impartial, neutral, trained, independent person, and does not have any personal interest in the potential outcome of the mediation. That kind of neutrality. He has no, or she has no personal interest in the potential outcome. His or her role is to create confidential, safe environment which encourages all parties to participate in the problem-solving process. A mediator is not a judge or an arbitrator, because those two make decisions. A mediator does not make decisions. It is the parties who make the decision. He simply, or she simply, assists the parties or facilitates their conversation so that they make the final decision, a decision, if I may use very loose words, that they can live with. So for this sort of a person, this trained person we are calling a mediator, his or her main role is to facilitate communication between the parties. That is really the main role. There are other roles I'm going to talk about, but the main one is to facilitate communication between the parties, to assist them in focusing on the real issues of the dispute, and to generate options that meet the interests, needs, and concerns of the parties. He does this, or she does this, in an effort to resolve the dispute, or for them to resolve their dispute. So in performing these roles, a mediator finds herself or himself transforming into many other roles. For example, a mediator transforms himself or herself into a coach. Now, throughout the mediation process, a mediator coaches the parties directly by sharing experience, making process suggestions, managing the parties' expectations, and indirectly setting the tone of the mediation. So in that way, then a mediator has transformed into a coach. A mediator also plays the role of a catalyst for problem solving. A mediator brings a clearer head and a creative mind to help parties construct an outcome that best meets their needs. A mediator is also a negotiator. He helps the parties, or she or he helps the parties to use effective strategies for making progress towards settlement. A mediator can play the role of reality tester. I'll give you an example so as to understand reality testing in mediation. There could be, at times, there could be a deadlock or an impasse. So a mediator then has to take on the role of reality testing. One party can, for example, say, I've been in this mediation, I'm listening to the other side. I don't think I want to continue. My lawyer has told me I have 80% chances of success if I go to court. So a mediator might do reality testing by asking the party, please share with me the 80% success that your lawyer has talked about. Just share with me so that I understand what you are talking about. So that's reality testing, when occasionally there is an impasse in mediation. And mediation can also turn into an information gatherer and identify common ground and scope for zones of agreement, gathers information, especially during exploration phase of mediation. When, for example, is going into private, the parties, he takes a party into private session and then takes the other one also into private session at different times, and of course keeps the confidentiality unless she or he is allowed to share that information. A mediator can also turn into an educator and explain the mediation process to the parties, the options and principles that may be considered. A mediator can also be a problem solver who enables the parties in dispute to examine a problem from a variety of viewpoints, assist in defining basic issues and interests, and looks for mutually acceptable options. A mediator can also play the role of facilitator. He helps the parties to overcome deadlock, just as I've already said, to find a way of working towards a mutually acceptable settlement. Now, in order for a mediator to successfully perform these roles, and there are many other roles, I just gave a few of them, many other roles. I think we can go to the next slide. The main role, or maybe the main role of a mediator, is to facilitate. A mediator needs a variety of skills, which in order to perform these roles, a mediator needs variety of skills, and I think we can go to the mediator skills. I think the next slides will show us the mediator skills. Say some of the roles of a mediator. I think I've said all this: information gatherer, educator, facilitator. I was explaining one by one: a catalyst, negotiator, coach, reality tester. So in order to perform all these different roles, what skills does a mediator need? Does a mediator need any skills? Let's see the next slide. Can tell us about the skill of active listening. That's a great skill for a mediator, active listening. The capacity to be a good and understanding listener is very important in mediation. because it's the basis of effective communication, active listening, just listening to what the parties are saying. Whether there are 2, 3, or 4 parties, listen. And then active listening includes non-verbal communication. And this is important, non-verbal communication, like body language of the parties. As you are listening to them, a mediator must observe body language of the parties. And this includes facial expression, gestures, postures, and the use of pitch. That's the tone, the voice pitch. Because no matter what we say, the sound of how we say it reveals a lot of how we feel and think. Now, matching, I think is here, is matching. Sorry, we have lost the, we were sharing a screen.
Moderator, please do the needfuls.
Yeah, we were sharing a screen.
Yes, yes, ma'am. So will be.
And I was on the skills. I was talking about the skills of a mediator as we were sharing a screen.
Krishna, please do the needfuls.
Yeah.
So Rahul sir has the PPT. He's just doing it. Sharing
Yeah.
it.
I'll wait. Okay. I'll wait for the screen. Otherwise, I can just go on. Shall we wait for the screen?
Yes, ma'am. For a moment, we'll fix it.
Yeah, it's okay. It's fine. The screen sharing, since I believe Rahul is also, somebody else is hosting, so I'm not able to do it from this end, but I'm patient. I'll wait.
Thank you so much, ma'am.
Yes, I see a question. Will we get the PP? Yes, I have the PPs on at your end now, so you can get them. Yeah. I see there's a question, how can a mediator act as an educator? In the sense that maybe the word educator, but in the sense that a mediator educates, trains, imparts the mediation process. There are stages to my mediation process, so that is what a mediator can impart onto the parties. That's what they are referring to as educator in that respect. I think I can go on because I was just talking about the skills of a mediator. If you allow me, I'll just go on. The slides are with you.
Ma'am, please go ahead.
Yeah, I think so. I was just talking about the skills of a mediator, and particularly, okay. Mediator skills include, but not limited to, active listening. I think I talked about that. The capacity to be a good and understanding listener, which is the basis of effective communication. You see, when you see that first slide, the mediator is seated normally in the middle. Parties are on both sides. It's a round table. So they are talking, and the mediator is listening very keenly, active. We call it in mediation active listening. And active listening includes it includes non-verbal communication, such as body language. Is very important in mediation to observe the parties' body language. Body language, you may not believe it, but it says a lot, just how you react with your body, how you sit, how you react. And then facial expression is also very important, facial expression. Gestures, you may make gestures. Here I am making gestures. And the use of voice tone. So active listening, observing nonverbal communication, that's important. Matching, this is developing rapport by accurate, matching is developing by accurate observation. This is really for rapport building. If you're developing rapport by accurate observation, you're observing the parties. Empathy, the ability to show the parties that you understand their interests and concerns through exploration and body language. Now, exploration is a stage in mediation, mostly done in private sessions, what in America is called caucusing, but the British, at least my trainers were not very keen on using the word caucus. They used private sessions. So that is when exploration, when you explore what is underneath the surface, what is it that is causing this difference between the parties. So you explore parties' personal interests, commercial interests, legal interests, and all other interests. So this is, the parties are also looking at you. You have to show the parties that you understand their interests and concerns. The use of silence and minimal verbal prompts. In mediation, the mediation process, sometimes it's necessary for the mediator just to watch the parties. You know, sometimes they're, despite the fact that you have given them, you have told them about grand rules that don't interfere, don't interrupt, wait for your chance, but sometimes things explode and they talk at each other's heads. So sometimes it helps to just pause and watch them for a while. And as you watch them, as a mediator using your skills, there's a lot that you learn about them as you watch them talk over each other's, I don't know how to put it. And when they realize you're watching and listening, you'll find that parties keep quiet. They realize that you're watching and they suddenly keep quiet, and then you resume. That's the use of silence and minimal verbal prompts. Then there's reflecting, paraphrasing. These are all very important in mediation: reflecting, paraphrasing. They help in mediation when you reflect. It is the technique of playing back to a person what the person has just conveyed to you. For example, you can ask the person, have I got it right that this and this is what you said? That you are reflecting on what they have said. Just checking with them whether you understood them actually. Then paraphrasing, briefly stating in your own words the essence of what somebody said. For you can say, so what you are saying is this and this, trying to understand, trying to make them correct you if you are wrong as a mediator. Did I understand you right? What you are saying is this. And then I didn't put it here, but I should have put reframing, changing the words or the way in which you present a party might say, for example, I want $5,000 out of this deal and nothing else. If this doesn't happen, I leave this mediation. So when you are reframing, you say, Mr. X, so money is important to you. What else is important to you? So that you're looking for other options. So or a party might say, I assess that I have 75 chances of success. And when you refrain, you can say, oh, I see you appreciate that you have 25% chances of losing. So these are skills that a mediator, you must know when to use reflect, paraphrase, summarizing. Summarizing is important because after the parties have talked, and then you need to summarize and say, 1 minute, let me summarize. Did I understand you right? Then the parties would say, no, I didn't quite say that. I said this and this. So it's important to keep summarizing what the parties have said. Whether you are in private session or whether you have both parties with you, you need to always try and summarize what they have said. I think we'll go to the second final. And I think I added here, but it's not in the slide. Okay, the 5 stages of the mediation process. There's the phase of the preparation. The first time you're meeting these parties, usually it's advisable to meet them, whether if they are represented by lawyers, it's advisable to meet the parties together with their lawyers. That is, for example, you have been appointed by an institution or you have been appointed by the parties themselves. Sometimes you may have to meet one when it's private mediation. Sometimes I've had to meet one party and get the contact of the other party. And there are several things that happen at this first meeting, and it's important because you're meeting the parties for the first time. They are also assessing you as a mediator. Half the time they are wondering, is this mediator a safe pair of hands, or that sort of thing. That is also when mediation agreement is also signed, after explaining to them what mediation, the process is all about, and asking them whether they are ready to sign the agreement to mediate, because they have to give the mediator authority to mediate, permission to mediate. And you also find out from them that whoever will be coming, whether it's an employment dispute or whether it's a commercial dispute, whether it's a family dispute, whoever is coming before the mediator, do they have the authority to consent should an agreement be reached between them? It's important always that somebody with authority appears at the mediation. Then there's the opening phase. Again, the mediator now formally again introduces himself or herself, requests the parties to introduce themselves. And of course, before introduction, seating arrangement in mediation is very important, and the mediator must take care of that. And then, of course, the confidentiality, the process is explained how it's confidential, and you know, the fact that they have come, it is voluntary, and they have come voluntarily, unless it is a court-annexed mediation like what we have in Kenya and several other countries, where the court screens the files and says this is suitable for mediation, and when the court does that, then you have to go to mediation. Whilst you are at the mediation, during the mediation process, whether you finally have a settlement agreement or not, that is left to the 2 parties or 3 parties. But once there's an order from the court, then you have to go for mediation. Then the exploration phase is really the negotiation phase. It's mostly done in private sessions. Then the bargaining, that's when parties start talking about figures or start talking about, usually they start talking about figures, because even if it's an employment mediation, there will always be something that parties are agreeing on, or whether they have been partners, there's always in business. So that's the beginning phase. And then there's the concluding phase of the mediation. So it's really a 5 stages of mediation. This is what the training of mediation is all about, because the mediators are trained on these 5 stages of mediation, of the mediation process. And then, of course, the skills that I've talked about. Yes. Those skills is what helps the mediators to take the parties through these stages of mediation. And I think we have a final Yes, we have a final clip. Now, I cannot conclude this without talking about what is happening now to mediation. The COVID-19 pandemic has changed the face of mediation. If you remember the first slide, can we just see that first slide again? If you look at the first slide, you can see this was a face-to-face mediation. And this is what we were used to here in Kenya. I don't know about India. But in Kenya, we did a lot of this face-to-face mediation. So we were able to very effectively watch the body language, expressions, non-verbal. We were able to do all that because this is what we were used to. But with the COVID-19 pandemic, we have now had to go to virtual mediation. It is challenging, but also very interesting. And we as mediators, we have to adjust to be able to conduct virtual mediation. Because we are conducting this mediation from, like now, for example, I'm in my study room in the house. And have conducted a few virtual mediations, not that many, not as many as I did face-to-face. People are in their houses or some are in the offices. So, and as if you remember that first slide, I'm not sitting with any person when, well, I'm sitting on my own, and so I cannot effectively watch the body language. So I'm relying a lot on facial expressions of the parties, because for example, what you are seeing now is basically from my waist to my neck and my head, waist, neck, head. That's what I also see when now I have parties on appearing before me for mediation. So we can't see their bodies, and mediation was like before. So what we are saying is that in this new normal, we still have to conduct mediation. We have to decongest the courts. And especially the courts, our courts were partially locked for almost 3 months or so. And cases have accumulated, have heaped. So mediation will now play a much more important role than before. It will be much more useful, and parties, we continuously tell the parties and the lawyers to consider mediation, because mediation takes very short time. The longest mediation that I've done in the last 3 years took me 1 day, from 9:15 in the morning to 6:30 in the evening. That was the longest session I had, with breaks in between, of course. Otherwise, most mediations would last just hours. And that's it. That is why, in my view, it is a preferred mechanism for resolving disputes. I'll be able to answer any questions. Let me check the chat box. Otherwise, I'll be able to answer any questions.
Ma'am, we have a few questions here. So
yes.
If you would allow, then I would like to present them to you.
Yes, I'm just checking.
Yes, ma'am. Ma'am, the first question here is from Kumar. I think you have answered that question, that how a mediator can act as an educator.
Yes.
And moving on to the next one, we have Nidhi Kalyani. She has a question that how can a party know that such mediator is not act as a reality tester? How can a mediator act as a reality tester? And
that's what I explained, that sometimes there's impasse or deadlock in mediation. So you test the parties. It's allowed in mediation, it's part of our training. If the parties thinks they have very good chances of winning this case, then you have to test them in that respect. And sometimes when you test parties, then they say, okay, maybe. Because when you go to court, you have to pay the court fees. the decision is not, you are not going to be part of that decision. The judge or the magistrate is making the decision on your behalf. But when you are in mediation, you and the other side, the mediator simply facilitates the discussion and the decision comes from the two of you. So all these are part of reality testing. So when you think about it, when you are just about to walk off from a mediation session, then you'll probably say, yes, if I'm going to be part of this decision between me and the other side, partners in business, husband and wife, employer, employee, then perhaps I better stay on. So that's really reality testing. Yeah, let me see. Another question is, how can a party know that such a mediator is not biased? A mediator is independent, neutral, and by the way, the minute that you as a party feel that a mediator is being biased, you are allowed to bring it to the table and say it, that madam or mister, I think you're being biased, or if you feel as a party that there is a mediator is biased, you got to bring it to the table. You got to bring it to the attention of the mediator, and then let the mediator either answer or take whatever action. Fortunately, nobody has ever complained that I'm biased, but I suppose it happens. Maybe that's why somebody's raising the question, isn't it? Perhaps it did happen somewhere. Yes, and yeah.
We have another question from Prithvi, and he's asking that, ma'am, do you think mediation will succeed in cases of bilateral disputes, especially during tense situations, howsoever the mediator is skilled? For example, can USA and Iran dispute be solved through mediation?
Krishna, can we ask participants to directly post their questions?
Yes, sir. Yes, sir. Yes.
Yes. So, do you want that participant to ask the question or to post it?
Ma'am, they will ask you themselves.
Okay. So let that participant put the question then.
Okay.
Krishna,
You can unmute yourself. You can.
Right.
Sorry.
Good morning. Sorry.
Yes.
Good evening, Honorable Justice. This is
Yes.
Prithvi Hegde, and my question is,
yes,
ma'am, do you think mediation will succeed in cases of bilateral disputes, especially during tense situations, howsoever the mediator is skilled? For example, can USA and Iran dispute be solved through mediation?
I think mediation can succeed in any dispute because the mediators are trained. And by the way, we now have the Singapore Convention. I didn't talk about that because it didn't quite touch on my topic, especially for international, disputes, commercial disputes of an international nature. But be it commercial dispute, be it family dispute, be it border disputes, be it the kind of disputes that you are talking about, I'm not sure that dispute has been, mediation has been given a chance in the dispute that you are talking about, has it?
I think it's not given, but...
And why not? It should be given a chance. Because sometimes it's true that mediation might not work, and if it doesn't work, then other people can move to other options. But I think it's always important to give mediation a chance, to give it a chance, because it restores relationships. That it restores the parties' relationship is restored if given a chance. If it doesn't work, then you move to other options, other mechanisms of resolving disputes.
So, ma'am, we have another question from Hamdan. Hamdan, you can ask your question.
Good evening, ma'am. Thanks for your time and sharing your knowledge with us. Understanding the culture of the parties is an important element in conflict resolution. Can you
Yes.
please elaborate this from mediation perspective?
Understanding?
The culture of the parties
Yes, it's
is
true.
always a key element in conflict resolution. So
Yes.
in terms of mediation, what is your view on this, especially when two parties are of a particular culture, and do you expect that the mediator is also aware of such culture before wanting to participate as a mediator?
It's important for the mediator to find out if I was, for example, mediating over a matter involving people of different culture, I would have to dig a bit more into it before. That is why there is preparation before the mediation. I would have to prepare before the mediation. I meet the parties before the mediation. I'll get to know what the dispute is all about before the mediation. This preparation is key to mediation. So, you don't have to wait until you get into a mediation session or before the mediation process starts. I think it's very, very important to be able to have to prepare. And the parties also, if they're the parties or those who nominate mediators, they also select very carefully. If there are issues to do with culture, they try to select the mediator very carefully. Yeah.
Thank you, ma'am.
Ma'am, we have another question from Marisport. Marisport,
Yes.
You can unmute yourself. You can ask yourself. You can ask the question yourself.
Yeah, hello, ma'am. This is Marisport, Dr. Marisport from Gujarat National University. Am I audible to you, ma'am? Hello, am I audible to you?
I can hear you, yes.
Ma'am, actually, I would like to know, have you seen any visibly challenged mediator who is having visibly challenge? Have you seen any such mediator, ma'am, in your life?
Confidential, nobody's to divulge anything. By the way, mediation is both confidential and without prejudice in that. Yeah. So when you take them private,
ma'am, may I?
yeah.
Ma'am, during private session, one party may his disadvantages or whatever the wrongs he committed. It might lead a prejudicial approach of a mediator. Don't you think, ma'am?
I didn't quite get that, please.
Ma'am, yes, ma'am. Let us take the example. A and B are having mediation. B might reveal that, okay, I have done this. There is a fault on my side. Okay, if that is the situation, don't you think mediator may tend to lose his confidence? He may say that, okay, B is actually fault. So his approach may be changing. Do you think, ma'am, that would be possible in case of mediation, especially during caucus?
No, it's not possible. During caucus,
okay,
people, the mediator encourages the parties to be free, to be honest, and I can only repeat what you tell me in private session. I can only tell the other party if you allow me. If you say, don't tell them this, I will not say it. I'll tell you an example of what happened once when I was mediating a family matter. And the couple were already living apart. They were not divorced. And it's not the divorce that brought them before me. It was the maintenance of the child or children they had. And the reason during private session, the wife told me one thing something that she told me, don't tell my husband. And of course I couldn't say it to the husband because she didn't allow me to. The husband was terribly very, very suspicious of her in terms of that she was not, his work took him a lot out of the house and for some days and months, and he was suspecting her of having an illicit affair. And as a result, they said the marriage broke down. So during caucusing, the wife told me, yes, my husband is away for very long periods. And yes, I have had a friend, a man, but please don't reveal that. So with that, with the confidentiality of mediation, I went on to other matters, but I did not bring that. I did not tell the husband that because I wasn't allowed to. But you may believe it or not, in that matter, the parties came to a settlement on how the children would be looked after, who was contributing what, and they signed a settlement agreement. So the mediator keeps a lot of secrets unless you tell. If she told me, tell my husband this, I would have told him when I went to the other room where he was, but he told me, don't say it to him. So that's how the court.
Yeah.
People,
Thank
parties reveal a lot of information that they cannot reveal. Yeah.
Yeah. Thank you, ma'am. Thanks a lot, ma'am.
The ma'am, the next question is from Shruti. Shruti, you can unmute yourself.
Yes.
I guess she's not online or she having some issue.
Okay,
Ma'am, her
Krishna,
question.
you may ask.
Yeah. Yes, sir. Ma'am, her question is, what is the basic difference between an arbitrator and a mediator?
Hello.
Yeah, Shruti is here.
The main difference is a mediator does not make a decision. A mediator helps the parties to negotiate, and the final decision is made by the parties, assisted by the mediator. The mediator does not make the decision for the parties. The parties make their own decision. In an arbitrator makes an arbitration award, makes a decision, just like a judge. When I was a judge, of course, for many, many years, I was making decisions. Now, I simply assist the parties, facilitate their discussions towards settlement agreement, and that settlement agreement must be in their own terms. I am in charge of the mediation process. They are in charge of making the decision themselves. That is the main difference between arbitration and mediation.
Hello.
Yes.
Good evening, Honorable Justice. This is Shruti Padhe from Law College, Dehradun. My second question is, how can a mediator change the mindset of a party who is not ready to compromise?
Using the mediation skills, we try to do our best. But there are some parties who come to mediation and they are very bent on not cooperating, not finally reaching any settlement. And we always tell the parties that you are free to leave the mediation, but before you do, can I have a word with you? So it's voluntary. Mediation is voluntary. You understand?
Yeah.
Yeah. So
Thank you.
Yeah.
Mukul Dev, you may ask your question.
Good evening, ma'am.
Yes.
Am I audible? Yes.
Yes.
My
Yes.
question is more of an opinion. And what
Yeah.
I want to ask is that you have been a mediator for such a long time. And what to you is the essence of the mediation? And with your experience, what is the best tip that you can give us as young mediators?
As young mediators, I hope that you have trained. It's very often people say, I'm a mediator, but they have not even trained. Please train as a mediator. It's very important that you train. And thereafter, you have to practice. You can be a co-mediator. You can watch if the main mediator and the parties allow you, you can watch the mediation in progress, but you have to be allowed by the parties themselves because they may not want any other person in the room. You can ask a mediator, can I be your co-mediator? And when you're a co-mediator, then you sit in the same room with the mediator and the parties, and you simply take over from where the first mediator, then where the main mediator, then you are the co-mediator. So it's not enough to train and then sit and not use what you have learned, because then you will not get experience. You need to get experience by, you know what, as they used to say, learn to speak by speaking.
Yes.
Yeah.
Thank you, Allah.
Ma'am, we have a last question from
Yes.
Nidhi Kalyani.
Yes.
Nidhi, you may ask your question.
Nidhi, I see her question here. What to discuss with a lawyer before going to a mediation process? Is that your question?
Yes, ma'am.
Okay.
Yes. Yes.
Now, please let me say that during the mediation process, lawyers have a minimal role to play. The key players at a mediation process are the parties, not the lawyers. The parties are free to get legal opinion even during the mediation process. Whether the lawyer is there or the party can ask me for time, a few minutes to call the lawyer. When the lawyers are in the room, the main and important people are the parties, not the lawyers. The lawyers will come in during the, occasionally as a mediator, I always ask the lawyers, that the lawyer for the petitioner, do you have anything to add? Do you have any question to ask? Otherwise, lawyers do not, you know what we lawyers do? Examination in chief in court, cross-examination, re-examination, that does not exist in mediation. Their role is to advise the clients. Even during mediation, they can do that. And then finally, during the drawing out the settlement agreement, but I always am present when lawyers are drawing settlement agreement. I never really leave them on their own. But what I do is also, I use a board in the, where we normally we go through the settlement agreement with the parties and the lawyers present in the room. It's written out so that everybody knows what is going to be typed. I prefer to have it written out, 1, 2, 3, 4, that's that. But the role of the lawyers is very important. It's very minimal during a mediation process, please, very.
Thank you, ma'am. Thank you for such a thought-provoking session. So, and I would like to request sanpreet sir to please add his closing remark and propose a vote of thanks.
Thank you so much, Krishna. It is indeed my pleasure to propose vote of thanks in today's session. Lordship, Ladyship has delighted us on the topic, which was role of mediators towards a successful mediation. And Ladyship has rightly said that mediation can perform much better role during these pandemic days. So nothing much to say. It was a very wonderful session, and so far as slides are concerned, that would be shared among the participants. Some of the participants are requested for it, and tomorrow we are going to have a session with the senior advocate Mr. Rajiv Datta, who is also a mediator in Supreme Court, on the topic importance and role of lawyers in mediation.
Okay.
And we have a surprise class also tomorrow, in which we are privileged to invite Honorable Justice Aluoch Singh, Judge of Uttarakhand High Court, along with Senior Advocate Mr. KTS Tulsi, who is also a Member of Parliament nowadays. And with this, I just propose a vote of thanks. Thank you so much, Ladyship, for being so kind and generous. And thank you so much, participants, for being so vigilant on the topic. Thank you so much. Thank you, Krishna. Thank you, Rahul.
Thank you very much. You have the slides, and I think you have my paper also. Thank you.
Thank you so much,
very
Madam
much.
Judge.
Thank you for asking me to speak. Thank you. Thank you.
We can just quickly welcome. I can see that Jitendra Mohan Sharma sir has just entered into the webinar. I would just request sir, if sir can hear me, to just kindly share his views, and so that ma'am, sir is, we have Mr. Jitendra Mohan Sharma with us. He's a senior advocate in Supreme Court and past president of Supreme Court Bar Association. Sir has been doing the mediation for quite long.
Yeah.
And sir, we have today leadership with us.
Sanpreet, this is one of the reasons why I don't want to come on video, and you are good enough to tap me whenever. Thank you, ladyship. It was a wonderful hearing you about the detailed role of a mediator which you narrated, and it was a wonderful experience. And mediator, and it's really a different experience for all students would be, because till now you have been hearing from advocates who are mediators only. Now you have been hearing a viewpoint of a judge who has till now been adjudicating matters, and now has shifted to a mediator to facilitate.
Yeah.
Thank you. This is with the few words I must thank Sandeep, thank the ladyship, thank all the participants. Thank you so much for calling.
You know what I'm asked all the time? Because I was a judge for over 30 years, maybe 40 years. All the time I'm asked, Judge, how did you transform yourself from making orders and to facilitating discussions?
Yes.
But I said that mediation makes sense to me.
Yes.
And in mediation, the fairness is in the process. So maybe it was easy for me to transform myself.
I know. It must be an enriching experience for all students, because it's a great, from a person who has been an adjudicating till now, and still some time back, and now facilitating to arrive at a settlement. Thank you so much.
Thank you very much. I decided to train myself as I'm also an arbitrator, but I don't practice arbitration. I decided when I was at The Hague for 9 years, when I had served for 7 years and I knew I had only 2 years to go, because at The Hague, at the ICC, we have to serve for 9 years. When I had only 2 years to go, I said, listen, when I go back home, I want to mediate. I want to be a mediator. And then that's when I started. I went to London, I studied mediation. And just last year, or early this year, that's when I qualified as an international as an international mediator. Because I'm still, if there are any other qualifications, I still go for it in mediation. Yeah. Thank you. Thank you. Thank you very much. Lovely.
Yeah.
Thank you, Rahul. Thank you, everybody. Thank you.
Thank you so much, ma'am.
Lovely. Thank you. Thank you. I'll leave the meeting now.